Good afternoon, everyone, and welcome to the webinar, Keep Calm and Understand Elonis versus the United States. My name is Emily Thrush, and I'm the project coordinator at AEquitas, the Prosecutors Resource on Violence Against Women, and I'll be moderating today's webinar. This webinar will explain, through the analysis of the court's opinion, what the opinion means for victims and for the allied professionals who support them, and why the Elonis decision is not cause for alarm. The webinar will also suggest strategies in charging and presenting evidence in cases involving threats or stalking on public forums, such as Facebook, to maximize the likelihood of a conviction that will stand up on appeal. Before we begin this substantive portion of our program, I will provide a brief overview of our ILINC webinar service. You can listen to this webinar either via computer or conference call. But for best use of ILINC, I strongly recommend calling in from a landline to the conference line, which you can see at the top left part of your screen, 530-881-1212. And the passcode is 202-731-738#. That number, like I said, is on the upper left-hand part of your screen. If you're using a mobile phone, please do not use the speaker option. Listen with an earpiece if necessary. And all the call-in participants will be automatically muted throughout the webinar. Today's webinar is being recorded for later viewing. To connect to internet audio, please click the Connect button on your start screen. If you use this audio option, please do not also call into the webinar. Only do so if you experience difficulty with your internet audio. If you have technical issues, you can use the ILINC hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen above the presenter's photo and to the right of the conference call number. Or you can contact ILINC directly at 800-799-4510. Today's webinar has a designated time at the end for your questions. Throughout the presentation, however, if you're unclear about anything or you'd like clarification, you can chat me your questions using the private chat option on the left-hand side of your screen below the attendee list. So you can just click my name, Emily Thrush, and private chat me, and I'll make sure to share your questions anonymously with the presenter so they can be addressed during the webinar. Today's webinar is hosted by AEquitas, the Prosecutors Resource on Violence Against Women, through funding from the U.S. Department of Justice Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and both presenters' biographies, will be emailed to you after the presentation. In addition, today's webinar is being recorded for later viewing. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. And Joan, I'll let you describe a little bit of domestic violence leap, DV leaps.
Okay. Thanks, Amy. Can the slide be forwarded?
Yeah, go ahead.
We need to forward the slide.
Oh, I'm sorry. I was just, I'll let you say a few words, but I'll just finish the introduction. I'm sorry.
I'm sorry.
Today's presenters are Teresa Garvey, Attorney Advisor at AEquitas, and Joan Meier, the Legal Director at Domestic Violence Legal Empowerment and Appeals Project, DV-LEAP. Prior to joining AEquitas, Terry worked for 22 years as an assistant prosecutor in Camden County, New Jersey, and for 9 years she was assigned to the Domestic Violence Unit. And for 5 of those years served as Deputy Section Chief of that unit. Terry worked closely with the Victim Witness Advocacy Unit to provide education to the public and community leaders who come into contact with domestic violence victims. Her jury trials—
Excuse me, Emily, can you advance the slides? I think we need to move up to the DV-LEAP slide.
Sure. So I'll just finish wrapping up, giving a small brief bio for both presenters, and then I'll pass it off to both of you. And both of you will have the full biographies emailed after the presentation. So yeah, Terry has jury trial experience and extensive appellate experience, and has briefed and argued numerous cases in the appellate courts of New Jersey. And Joan Meier is a professor of clinical law at George Washington University Law School and the founder and executive director of DV-LEAP. Joan founded DV-LEAP in 2003 to provide pro bono appeals in domestic violence cases. DV-LEAP has filed 9 amicus briefs in the U.S. Supreme Court, including in Elonis. Joan Meier has been a clinical law professor for 22 years, where she founded, and at GW she's founded 3 pioneering and nationally recognized interdisciplinary domestic violence clinical programs. She has also published widely on domestic violence, including a recent piece for the Domestic Violence Report on the Elonis case. She graduated with honors from Harvard University and from the University of Chicago Law School, and clerked on the 7th Circuit Court of Appeals. And like I said, their bios will be passed on. And I would now like to give the floor over to Terry.
Okay. I'm not being able to advance the slide, and I'm still seeing the AEquitas slide. So I'm not sure why it's not advancing.
Okay, just bear with us one moment and we'll try to work this out.
Okay.
Okay,
Are we
Terry,
missing the DV-LEAP slide?
All right. Yeah, let's just go back so we can see.
There we go.
This is DV-LEAP slide. Joan, do you want to just add anything to what that?
Well, yeah, because I think we haven't gotten to this yet. I just wanted to say a few words about DV-LEAP and our role in the world. Our primary mission, as you can tell from the title, is appeals. So we do appellate advocacy in the form of direct representation and amicus briefs all over the country and in the Supreme Court. But we do a lot of other things as well. We do a lot of trainings of judges and lawyers and non-lawyers and experts. And we provide enormous amount of technical assistance directly with survivors in court and their lawyers and advocates, and a lot of referring and linking of people with experts and adequate representation. We also do a fair bit of legislative advocacy when it grows out of an issue we've worked on in court, and in fact, Elonis is one of the cases that's going to apparently give rise to that kind of a project. The family reference at the bottom of the slide is just referring to the fact that a lot of our work focuses on keeping children safe in the context specifically of family court litigation around custody. We have quite a few cases of that sort, and we do an enormous amount of law reform and advocacy and training around those issues. In fact, that's the primary area where we're usually asked to do trainings. But we also have our hand in criminal law areas like Elonis and other things like constitutional rights, confrontation rights, and a whole variety of issues that find their way up to high-level appellate courts that relate to domestic violence. And that's it for now.
Okay, thank you, Joan. And it's really, I'm really thrilled to be presenting with Joan, and I'm looking forward to working with her a lot more in the future on matters that we have in common interest. And there's Joan's.
It's mutual.
You can see both of us. Okay. All right. So the title of the webinar, Keep Calm and Understand Elonis versus United States, is really recognizing the fact that, and I think it's reflected in the number of people who are participating in today's webinar, the fact that so many people had a certain degree of concern or even alarm in some cases when we start seeing some headlines. The New York Times on June 1st, and remember this case has only been around less than 2 months at this point, Supreme Court overturns conviction, and of course the great news, the Supreme Court on Monday made it harder. How many of us want to hear that when we're talking about the job that we do, which we already know is hard enough on a day-to-day basis. And the U.S. News and World Report, the same day, Facebook Wrapper, which is probably giving Mr. Elonis a little more credit than he deserves from an artistic point of view, because a lot of his artistic expression was derivative, to say the least. But we are, free speech rights dodged a bullet. So, and it makes it sound like it's a fight between advocates or people who support women and people who want to honor and protect the First Amendment. And I was a journalism major in college, so I'm certainly a First Amendment defender. But so if until you read the opinion, you would naturally have, being in our line of work, a certain amount of concern. We're all wondering, is this another Crawford versus Washington? Is this going to change life as we know it in the courtroom? Are we still going to be able to protect our victims? Are we going to be able to hold the abusers accountable? How much does social media have to do with what's happening here? I mean, these days, our victims, our defendants, our jurors, our judges, everybody often spends as much time interacting with people online using social media as they do in face-to-face interaction. Can abusers put their threats in rhyme form or post it in meter notation as you do in poetry, and thereby have your threats enshrined as some kind of artistic expression? Is that going to allow them to get away with making these statements if they just are clever enough to couch it in the right way? And the bottom line for all of us is, what is the impact for us in our practice? If we're going into court trying to prosecute these cases, threats, stalking, harassment, or if we're civil attorneys who are trying to assist our clients in obtaining protective orders, and maybe in our jurisdiction we have a statute that requires us to show that the defendant committed a criminal offense under our criminal statutes before we're even entitled to a protective order. How is that going to affect it? And if you're advocates and trying to explain any of this to the victims that you're working with, what do I say to them? What do I tell them? So it's important for us all to think about that and, try to understand this case and maybe get it down to right size so that it's not the looming emergency that some of the headlines suggest that it is. It turns out when you actually take apart the Elonis decision, when you actually look at what it says and does not say, it really doesn't change much in and of itself. The decision itself was construing a federal statute. It was a very specific federal statute. It happened not to have any kind of culpability standard for what the defendant's state of mind had to be at the time he uttered or posted the threatening statement. So what the Supreme Court did was it looked at it and said, well, there is no specific culpability standard. The trial court implied a negligence standard, and the Supreme Court said, unless a statute really specifies negligence as the standard of culpability, it really should not be implied, because negligence is normally something that's an accident. If someone has a fender bender on the highway and they were looking down or trying to settle the dog down, or the baby's crying in the back seat, they get momentarily distracted, and it's really an oops. You can have terrible, terrible, tragic results, but the person who is in that position isn't really as blameworthy as someone who, let's say, gets behind the wheel drunk, and then you're going into reckless conduct. They may not be intending to do it. They may think they're okay to drive, but nevertheless, by getting behind the car impaired, they're behaving recklessly. And the court said, you have to at least be reckless before we're going to hold you to some kind of criminal liability, except in very unusual cases where statutes really specify that. So they said that, we really shouldn't be just implying that or reading it into the law unless it really specifies that. And because the court made its decision based on the fact that the trial court applied the wrong standard, applied really a negligence standard when they should not have, the court did not even get to the question of what standard is necessary in order to satisfy the requirements under the First Amendment, freedom of speech. So the court didn't even reach that claim. So when you boil it all down, that's really what the case itself says in so many words. So just to review what the Elonis case was actually about, Anthony Elonis was separated from his estranged wife, Tara, and he was not taking it well, evidently. He had been sent home from work on at least one occasion for crying at his desk. They sent him home. In the time period following that, he had several sexual harassment complaints filed against him with the company that he worked for. He worked for an amusement park, Dorney Park in Pennsylvania. And his coworker filed several sexual harassment complaints against him for bizarre behavior that he was engaging in with her. And after he was spoken to, or I think he was suspended or something briefly, he then posted on his Facebook account, on his webpage, his Facebook page, a photo of him at the amusement park's Halloween haunt event. And he was in costume. All the employees were in costume. And he is in the photograph holding a toy knife to the coworker who had filed the sexual harassment complaints against him. And the caption on the picture was, "I wish." That was one of the counts, the first incident for which the defendant was charged ultimately in this criminal case. He then, as a result of posting this inappropriate photo of him holding the knife with the caption, "I wish," he was fired from his job at the amusement park. And he then posted on his Facebook page a post suggesting that the park evidently believed he might have taken keys, or he might have an intention to break back into the park and do some kind of unspecified harm to either the park employees or the patrons. And because of the way that was stated, which kind of suggested that he was indeed a threatening person of whom you should be afraid, that was the second count. I don't know if it was literally the second count, but it was the second incident for which he was charged in this criminal case. He posted a number of statements and posts that were construed as threats against his wife. Several of these were couched as rap lyrics or written in a way that a rap lyric might read. And he also posted other kinds of posts. But what's interesting about Mr. Elonis is apparently up until these threatening or scary posts, he had expressed no interest in rap music. He was not a budding lyricist. He was not somebody who was trying to build a career. He was not a budding Eminem. So this came out of the blue, and it was solely in connection with these threatening type statements. Among the statements were things expressing there's only one way to love you, but 1,000 ways to kill you, talking about leaving his wife's body a mess soaked in blood and dying from little cuts. Hurry up and die, bitch. He also, being not that terribly original, posted a parody or an adaptation of a comedy routine that was done by a comedy troupe. And the original was, "Did you know it's illegal for me to say I want to kill the president?" And the comedy troupe had done a skit where someone was saying that, and of course he was repeating over and over again threatening statements, but saying, of course, that doesn't really count because I'm not actually saying it. I'm just saying it would be illegal for me to do that. However, one of the parts of the skit talks about how it would be really, really illegal for him to tell someone how they could go to her home and fire a rocket launcher through the house and into her bedroom. And it was accompanied, what the victim found threatening and scary, was that it was accompanied by an accurate diagram of her home, showing the entrances, showing how an assailant could get in and do harm to her. At that point, the victim did obtain a protective order. So the defendant was certainly on notice at that point that she was claiming that his posts were frightening her. And in response to that, he posted on his Facebook page, "Fold up your PFA, your protection from abuse order, and put it in your pocket. Is it thick enough to stop a bullet?" He also posted a threat to commit what he referred to as the most heinous school shooting ever imagined in a kindergarten classroom. He said there were a number of elementary schools in the area, and the only question was which one should he go visit to do that. And he also posted, after he posted that, the FBI went out to have a little chat with him. And after that chat, wherein he was quite uncooperative with the FBI, he posted another quote-unquote rap lyric talking about how he wanted to cut the throat of the little agent lady who came to talk to him. Throughout these various posts, he posted various disclaimers. He claimed that his posts were fictitious. He put like a little asterisk and say that there was no intentional resemblance to real persons. He also posted various references to his constitutional rights and freedom of speech. And when apparently one of his Facebook friends expressed some concern to him about the nature of what he was posting, he responded that he found the post to be therapeutic, and he testified at trial that the post helped him deal with the pain. Now, he was charged for these various posts under 18 United States Code Section 875C, which states, "Whoever transmits in interstate or foreign commerce any communication containing any threat to kidnap any person or any threat to injure the person of another commits a federal offense." Now, you'll notice when you look at that, it doesn't say whether the person making this threat had to intend that it be threatening or what exactly his state of mind had to be with regard to the threatening nature of the statement. And the trial court, after some arguments before the trial court ultimately, Elonis was arguing to the trial court that the jury should be instructed that he could not be convicted unless he absolutely intended to threaten his wife and these other people in these statements. The trial court, however, said that in order to find Elonis guilty, the jury had to find that he intentionally made a statement in a context or under circumstances wherein a reasonable person would foresee that the statement would be interpreted as a threat. So it was really holding him to a negligence standard in that the jury could not find him guilty unless he was careless about posting something that someone else would find threatening. And again, the Supreme Court's opinion notes that the statute did not specify the mental elements of threat and held ultimately that the trial court erred by implying a negligence standard, and that usually can be recognized by the words reasonable person. So different states have different ways of identifying the mental element. Virtually all crimes require both an actual act that's illegal, but it also has to be accompanied by a specific state of mind. And many states still use the old concept of general intent or specific intent, which are not all that clear. Scholars and judges and other legal professionals disagree about what those terms really mean. The model penal code, which is followed to some degree or other by most states, break it down into 4 different mental states according to how culpable or blameworthy the offender is. The top or the most blameworthy are acts that are committed either purposely or intentionally, which basically mean the same thing, and that's where your conscious objective is to do something. Next down is knowingly, which is where maybe it isn't your specific purpose, but you're consciously aware of the situation, of what you're doing, of the nature of your conduct, and that a specific result is practically certain to follow. Recklessly is a less culpable state of mind. That's where you're aware that there is a risk that something will happen. You see the risk, but you're consciously disregarding it. That's what reckless conduct is. The person who gets behind the wheel of the car, they know that there's a risk if they're driving impaired. They may not have the intention to drive impaired. They may think that they're going to be okay, but they still are aware of the risk and they're disregarding it. And on the other hand, negligence is the lowest standard, and very few statutes, criminal statutes, as we said, impose a negligence standard. And that's when you fail to perceive the risk that a reasonable person would, or fail to behave as a reasonable person would. The court did not decide whether recklessness would be sufficient under this federal statute, or whether this prosecution must prove at least knowing, if not intentional or purposeful conduct. It also did not determine what the mental state would have to be in order to satisfy the First Amendment. And there was a concurring opinion filed by Justice Alito, who was very critical of the fact that the court did not make that decision, did not hold whether recklessness would be sufficient or not. And Justice Thomas, who filed a dissenting opinion, also had the same criticism. So that question the court specifically did not decide, and their reasoning for that was they claimed that it was not sufficiently argued by the parties, and they would wait until a case that squarely presented the question came along. But when you think about the actual Elonis case, and many of these cases, how hard really would it have been for the prosecutor to prove that Elonis intended to threaten his life? Really, when you look at the context, when you look at the history, when you look at the fact that, for example, he apparently was able to make sure that she had the opportunity to see his post. And beyond that, or even less than that, it certainly would be easier to prove that he, knew that she would find the post to be threatening, and easier still to prove that he recklessly disregarded the risk that she would find the post threatening. Again, given all the context, which we so often do have in these cases. The context is critical. In Elonis, for example, we have the fact that he had previously expressed hatred and a desire to get even with his estranged wife. He knew that she had obtained a protective order, at least at some point in these proceedings, wherein she expressed how frightened she was of his post, and yet he continued to post. We have the fact that he was aware law enforcement was viewing these as threatening statements, and he was consciously certainly disregarding that and continuing to post even in the face of that response. We have the fact that he had no prior history of any kind of interest in the kind of artistic expression he claimed he was engaging in. And the fact that he even posted all these little disclaimers around indicates that he knew exactly how those statements were going to be taken. And if someone is really threatening you and frightening you, then saying, just kidding, doesn't really cut in terms of eliminating that feeling of fear. So what actually is the impact, if any, on our state and tribal prosecutions? What can we do to incorporate what we know now about the Elonis decision and some of the information that the decision suggests might be important in prosecuting our criminal cases. And Joan, if you want to talk about it in the context of protective orders.
Sure. I'll just say that when DV-LEAP filed our amicus brief in this case, we wanted to make sure to say something different so that there wouldn't be overlap among the amici and among the party briefs. And we thought it was really important to explain to the court that even though this was a criminal case and a criminal law question, that it could have a significant impact on protective orders and the ability to protect victims in the civil setting. And we found to our surprise, I mean, in D.C. where I practice and used to practice at trial, we have to prove a crime in order to get a protection order. That statute's explicit about that in terms of how it defines the interfamily offense. We found to our surprise that when we did 50-state research that about half the states have the same requirement. So it became very clear that however the crime is defined, at least strictly speaking and technically speaking, if it's harder to prove as a crime, it's going to be harder to prove for protection order purposes as well. And so DV-LEAP's brief made the point and explained how many civil courts will follow criminal law standards even when they really don't need to, but here in at least half the states they do need to, and said I didn't want the court to be able to fall back on the idea, well, we'll protect defendants' rights on the criminal side, but this won't affect civil protections. I wanted them to know it will affect civil protections, and there's not an easy answer in that regard. Okay. Over back to you, Terry.
So really, as we saw, there's not a direct impact to the extent we're talking about state and local or tribal prosecutions because it involves a federal statute, for one thing. It doesn't apply specifically to our cases, our statutes. Our statutes might or might not have a specific mental element specified, and they might or might not have a default mental element that is supplied when the individual statute does not have one. The holding is specifically limited to prosecutions under federal law. It's only binding precedent with regard to the cases that are in federal court that are involving this statute. So that's one thing to know. That doesn't mean it won't have persuasive effect. It may have a great deal of persuasive effect and impact on, as a practical matter, on our cases, but it is not a matter of binding precedent with regard to the issues that were actually decided by the court. It's also important to know that the court did not decide any constitutional issues regarding freedom of speech in this case. We have some hints. We have some indicators in both the majority opinion and in the concurrence and dissent how the court in some future case where it's actually where their collective feet are put to the fire and they're forced to decide whether recklessness is sufficient or whether it has to be some higher standard under the First Amendment. We can try to guess. We can try to make an educated guess, but there is nothing in the case in and of itself that determines what that First Amendment protection is going to be. It's also interesting to know that there is nothing in the opinion at all that talks about the significance of the fact that these statements were posted on social media, online, as opposed to being made in person, in a letter, in some other form of communication, publishing in the newspaper, leaving a note on somebody's car. There was nothing significant about the online aspect of it that would make a court or should make a court treat a threat any differently than it would if it were made in some other fashion. And Joan, I think you were going to talk about this. Okay. Well, I know that in our discussions.
Oh, I'm sorry, Terry. I was muted. I just unmuted.
That's quite all right. Go right ahead.
I wanted to make sure that I'm audible enough because apparently I wasn't completely audible last time. So if Charlie or someone can send me a note as I continue to talk and let me know. So the point here is that actually Terry and I had a bit of a dialogue about this. I mean, she was like, this is a federal statute. It's got nothing to do with us. And I'm saying, well, I think it has a lot to do with us. So I got the however slide because I think that and based on my work on the brief with some Supreme Court lawyers, I actually went back to some of them after the decision came down and I said, what is this decision? It's not strictly constitutional, but it sure sounds constitutional in the way the court is sort of issuing these broad principles about the way things have to be to protect defendants' rights. And the answer I got, which actually worked for me from my friend at Morgan Lewis, David Salmons, was that there's this sort of long tradition of the court construing adopting criminal law jurisprudence in such a way that it sounds kind of constitutional. It's very fundamental. It's very much about defendants' rights, and it goes to the heart of what we think is permissible when it comes to holding someone in violation of the criminal law. That all the language in the decision about a wrongful mind and knowing you're doing something wrong. And basically what he said is, yeah, it's not really constitutional, but it kind of might as well be because it's this very set of fundamental principles about how we construe the criminal law. So to the extent that it's understood that way, I think many state courts are going to follow suit from what the court did here, even though that was a federal statute and it's different from the state laws. A. And B, many of the state laws are similar to the federal one in the sense that they don't specify an intent standard. And courts have been construing that however they have been doing it. Actually, footnote here, important point is that the vast majority of courts, state courts, and I think 9 out of 11 federal circuits had been using the reasonableness standard, which is being called here the negligence standard. That has been historically the standard way to prosecute threats. There was a minority of federal circuits and states that chose to go further and require specific intent, but the vast majority historically and currently have been prosecuting threats with a reasonableness standard. And so I think a lot of these state laws that don't specify intent, there's case law, as there certainly has been in D.C., hashing out the intent question, and vast majority have said reasonableness is enough. So now we have the Supreme Court saying, well, as a matter of federal law, it's not. That's mere negligence. That's not adequate under our traditional criminal jurisprudence. We're going to require more. So I would expect many state courts to feel that they have to follow Elonis, although I also agree with Terry that if you're in a prosecution or advocacy role on behalf of the victim, you're going to want to explain very forthrightly that Elonis is in no way controlling or binding, that the state law does not have to follow what the Supreme Court said here. The state courts are free to do what they've been doing all along and just simply distinguish the law at issue. But you got to be ready to argue the issues because I think many courts are going to want to.
Yeah, and that was the point, too, about be prepared for the court to find that it is because you may lose that argument for the exact reasons that Joan just mentioned. So it's something, and Joan and I did have some lively discussions about some of this. Of course, this is a lot of this stuff is where reasonable minds do differ, and that's why we all went into the practice of law because people always have a job because nobody's ever going to agree on everything. But I certainly respect Joan's knowledge on this area.
Totally mutual.
and it's important to know, too, that there will be free speech cases coming. This case has only been out for 2 months at this point, but I just became aware of a case that was decided on August 3rd in Illinois. It's not at this point a published decision, but I don't know if it will be in the future, but it's People versus Dye, D-Y-E. And what that case involved a defendant who was having a dispute with his public defender who he felt was essentially selling him down the river, apparently. He didn't feel that he felt that she turned over some material to the prosecution that she shouldn't have done, and they had a very angry discussion in her office. And she finally told him to leave. And as he got up, he had already made a threat that he was going to complain to the judge about her, evidently. But as he stood up, and he apparently was quite a large and imposing man, and he came towards her in a threatening way. She was certainly very, very frightened. And he said, "I'm going to get you." And at that point, he was sort of grabbed by the office staff and escorted off the premises. I'm sure that is not that unusual an occurrence in public defenders' offices. But in any event, he was charged with making a threat against a public official, in this case, a member of the public defender's office. And what the court did was, for reasons that kind of escaped me, they went straight to the constitutional issue, although I think it could have been decided based on the fact that the threat was not clearly a threat. It was not clearly intended to be a threat because, as they point out, saying that you're going to get somebody is susceptible to a lot of meanings, including complaining to the judge, which he had just said he was going to do, complaining to the disciplinary board or the bar authorities. There are a number of ways that someone could be got without being physically threatened. She was, however, very, very frightened, the attorney was. And but instead of just deciding it on that basis, the court went further and said not only was recklessness not sufficient to constitute a true threat, it interpreted Virginia versus Black, which is a U.S. Supreme Court case dealing with cross burning with the intent to intimidate. So that was a statute that actually already had a specific intent requirement. And Elonis indicated that knowing conduct was not sufficient. It actually had to be purposeful, intentional making of a threat. So the point is these cases are already starting to trickle through, and no doubt at some point the Supreme Court will be called upon to make that decision, and that's just one of the cases that may be coming our way eventually.
Terry, may I just add one thing?
Oh, sure.
From my quick look at that opinion, I think the court, it was just very flawed. Elonis specifically says knowledge is sufficient. So they're contradicting Elonis, as they kind of cite it as a C also. And they're completely misreading the other Supreme Court decision. And I think they're just excited by the whole issue, and they sort of make some law.
They need to keep calm and understand the law.
Right.
So, everyone take a chill pill, including the courts. So, and actually, if you read the Elonis opinion, it doesn't say in so many words that knowledge is okay. It says there is no dispute between the parties, but certainly they didn't express any concern about knowledge. I think it's clear to me anyway that the court would find knowing conduct to be sufficient. So I don't know where the Illinois appellate court got that idea, but in any event, it is what it is. Joan, you want to talk about this?
Sure. So that leads us to recklessness, which is kind of the middle standard in terms of the intent requirements, the schema of potential intent requirements. And I will just mention that DV made the argument in our brief as kind of a fallback. We said we think reasonableness standard and objective standard is fine under the First Amendment and in any other way, but if you don't go beyond recklessness. Recklessness should be more than enough. And we just put that out there because we were getting great advice from a First Amendment scholar that we know well named Steve Heyman at Chicago Kent Law School, and he sort of thought that was not a bad fallback for the court as well as the rest of us. And as I thought about it, I thought, yeah, it's not going to be hard to prove recklessness in the average DV case, certainly not in Elonis, but probably not in many cases. We can live with that. So we put that in, and of course the court did duck it. But what's interesting is that it gets a lot of play in Justice Alito's concurring decision, and it's implicitly more than enough in Justice Thomas's dissenting decision. And as actually Justice Thomas actually points out that that if you start counting votes, you can see there's a majority of the court that would support recklessness. That is my opinion too, and actually that's the next slide. But both Alito and Thomas point out that there's a number of exceptions, First Amendment protection for certain kinds of speech that do not require heightened intent, that will allow varying degrees of unaware defendants to be found guilty of obscenity or other speech crimes in certain circumstances, and therefore the mere fact that this involves speech does not automatically elevate the intent requirement. Can we go to the next? Yeah, so if you count the votes, Thomas actually says what he calls general intent, which basically means he knew what he said and what the normal meaning of those words were in the context in which they were uttered. That's enough, and I'm equating that to the negligence standard, although Thomas himself makes a point of not doing that. I'm saying it's different, and it is different technically, but at least in terms of the sort of the demandingness of the standard, it's kind of like an objective reasonableness standard. And Alito explicitly says recklessness is more than enough, and in fact he says we don't have any business requiring more than that when there's a statute that doesn't require any kind of intent. That would be amending the law rather than interpreting the law. We have to require something more than negligence. He agrees with that because we're talking about criminal culpability, but any more than recklessness would be basically becoming legislators. That's sort of how he carves it out. And of course he applies that to the Elonis facts and points out how easily recklessness would have been met. Now, if you think about the numbers, had there been 5 justices voting for specific intent like Elonis was arguing, there would have been a majority opinion saying that. So what we have instead is a 7-justice majority opinion saying not that, saying we don't know about recklessness, we know specific intent is plenty, and we know that negligence isn't enough. What that says to me, and I think Thomas reads it the same way, is that there were probably less than 5 of those who were ready to vote for specific intent, which means there were 3 or more who were ready probably to vote for recklessness. If you add those 3 to Alito and Thomas, you've got a majority on that court for recklessness. So I think recklessness, at least as a matter of criminal law, is more than sufficient when it is a court construing a statute that doesn't specify. Now, I want to make a clear distinction, though, that if a legislature chooses to specify an intent, they are still free to specify negligence or recklessness or specific intent. This whole decision is predicated on the idea that the statute says nothing about intent. And the court majority clearly says we have to infer one when the legislature hasn't stated one. It does not say that the legislature may not adopt a negligence standard. In fact, it says repeatedly, as does the Model Penal Code, that there are some crimes for which a negligence standard is sufficient. And they don't go anywhere near saying whether and when that would be okay in a speech case. But of course, as Terry has emphasized and we will continue to discuss, because it's speech, I think adopting a negligence standard is going to be a lot dicier than it would be in another type of crime.
Okay, so the concern with the negligence standard, and as Joan indicated, I'm a little more leery of it, I think, than she is. But I have a concern that statutes, when the court is called upon to decide the issue explicitly, I think they're going to find that a negligence standard might chill legitimate speech, that someone who is merely careless with regard to his words should not be punished criminally for his speech, whereas someone who is reckless about it could appropriately be. And we'll have to see how that shakes out. I think that if you read the concurring and dissenting opinions in Elonis and some of the cases that are cited therein, some of the free speech cases that are addressed, that's kind of the conclusion that I came to. But we have to remember that even if negligence isn't enough, almost all of these abusers have left a trail, a whole wake. You could follow it without a magnifying glass of what their intention is. And it's going to show at least a reckless state of mind and usually purpose or knowledge. So I don't think that it's going to be that difficult a standard to meet, a recklessness standard. So my recommendation or suggestion would be, to the extent you have to choose a standard, or if you've got a statute that deals with negligence specifically, you might want to try going for the recklessness standard. And I'll talk a little bit more about that in a minute. So some of the crimes that might be implicated or that might implicate issues under Elonis are threats, harassment, stalking. They're all similar kinds of statutes. and they sort of differ in the amount of emotional distress they may cause to the victim. Harassment may be relatively little. A threat or a stalking statute might involve a higher amount of emotional distress that's intended or risked or caused as a result of the conduct. And they also differ in their repetitiveness. Generally, threats can be accomplished with a single statement. Harassment and stalking tend to most often require more than one incident to show sort of a pattern of conduct. But they're all similar kinds of cases, so you could have these issues arise in prosecutions or obtaining protective orders under any of these three theories, I think. So the first step you need to take is to analyze your statute, read it. Number one, read it. When all else fails, read the statute. I'm sorry, Joan, I think you were going to talk about this, and I stepped on you.
Oh, no, not at all. I thought we were both. But, yes, read your statute, but don't be surprised if there's no intent standard in it. And then you want to look at your case law, because typically if it doesn't specify in the statute, there's been case law on the subject. It's been battled out over the years. So you're going to want to look, the statute and the cases and see, because if you're already at specific intent or recklessness, you really have nothing to worry about, and you've already been probably practicing under that standard for a while.
Yeah, and it's also important to know if your statute doesn't specify a mental element in terms of the offender's conduct, check and see if you have a statute that supplies a default mental element where the statute is not specific. Many states have that. I practiced in New Jersey. We follow a version of the model penal code in terms of the culpability standards. And the interesting thing is, I believe in New Jersey, the default standard is knowing, which is, I think, the highest in the country. Most states supply, some states supply a negligence standard, some imply or supply a recklessness standard as the default standard if it's not clear. So you want to check and see if you have one of those default provisions. And if not, again, as Joan said, check to see if your case law has already said what the standard is for that. So our conclusion is that intentionally or purposely, which are really the same thing, or knowing, which is the next lower level of conduct, under Elonis and the First Amendment is probably going to be okay. Every indication is that one of those standards will pass muster under the First Amendment as well as Elonis. Reckless conduct is not decided because the court specifically said we're not deciding it, but again, for the reasons that we already talked about, it's likely that that is going to pass muster with our current court as well. With regard to the negligence standard, that's up in the air. It's not decided. There is some constitutional risk involved in that. So you may want to be careful if your standard is negligence. The way you can tell if you have a statute that has a negligence standard is when they talk about reasonable person when they're referring to the defendant's state of mind. When reasonable person refers to the victim's state of mind, there's no issue at all. And I had this issue come up recently, just this past week, with a prosecutor from Texas who had a stalking case that she was preparing to try, in which the defendant had filed a motion to dismiss filed a motion to dismiss the case, saying that their statute was constitutionally infirm because of Elonis. And their statute actually has an explicit mental intent requirement. They require specific intentional conduct. So it's the purposeful, intentional, highest standard. But he was looking at the fact that the statute required not only that the actual victim feel threatened, but also that the victim was acting as a reasonable victim would. And he was arguing that that was somehow incorrect under Elonis. The prosecutor had no problem understanding the distinction, but she was having a little trouble explaining it to her judge, who sort of saw that reasonable person language and, the antenna went up. So just to make that clear, when we're talking about reasonableness on the victim's part, that's really for the defendant's protection, because it protects him from being prosecuted for what an especially or unreasonably sensitive victim would find scary or offensive. Joan,
okay,
you are.
me, right? Okay. So one thing that I learned as I worked through the brief in this case and talked to prosecutors who were working on it, some of them actually said that their counterparts in the specific intent states, and as I said, there's a minority of states that use that their counterparts say that it's really not much harder. And the reason they could at least make that claim is that even when we're talking about the defendant's purpose or intent, juries and judges necessarily have to look beyond the brain or the assertions of the defendant to discern that. So they're going to look at the same facts and circumstances that point to what the defendant's mental state had to have been, even when he's like Elonis up there saying, no, I never intended it. It is virtually impossible to look at the facts in this case and say, no, he didn't intend to frighten people. That clearly was his whole agenda. And you can see that from the situation and the context and the protection order and the FBI, all of the things that were happening that he was responding to. So on one level, we shouldn't worry even if we have to meet specific intent and recklessness, and it's in any case, as Terry said, even if we have a negligence standard in our case law or our statute, we should be careful to prove more than that if we can, argue for more than that, argue that the evidence proves more than that in case negligence gets struck down. And I think that shouldn't be that difficult, as Terry is suggesting, in most of our cases. On the other hand, I think it's fair to say that obviously a higher intent standard makes it a little bit harder to prosecute. And the way this all sort of boils down in practice is that it's kind of like a different burden of proof. If your evidence is pretty clear that he almost certainly knew what he was doing, you're okay with a recklessness standard, but it's not clear you'll be okay with a specific intent standard unless it's super clear that he had to know what he was doing. So it's, that's my kind of personal reinterpretation of what these mens rea intent standards really mean. They're in some ways complete fictions because we're inferring and we are projecting into the defendant's head what he thought or supposedly thought or knew. And it really boils down to how much evidence, how much proof you really have, and how certain the jury can feel.
And I think from a practical standpoint, that's really important to remember. So we want to be presenting the maximum evidence we can of that culpability standard, including any history of violence or threats. This is a great situation for bringing in 404B evidence because all of that is going to shed light on how the victim would have perceived it, what the defendant knew about how she was going to perceive it, any history of protective orders, because those generally are putting the defendant on notice that the victim is feeling fear as a result of its conduct. Any evidence showing that the defendant knew the victim would be fearful. Maybe messages were passed. Maybe she had her brother call him up and say, listen, knock it off. Maybe she had her friends talk to him. Maybe there were other kinds of communications where she said, look, I just want to be left alone. You're really freaking me out, or you're really upsetting me. And any communications like that is going to be very important to show, what that defendant's intention was. And any other context, including things that might be known only to the victim and the defendant. I've had stalking cases where a victim was threatened by finding leaves covering her car because the defendant used to tell her that he was going to kill her and bury her under the leaves and no one would ever find her. So anything like that, if she posted something on social media, talking about, aren't the leaves lovely this time of year, hint, hint, something like that, that might shed light on what he meant by that and what his intention was and his knowledge that she would find that threatening. It's also important, of course, to bring in any evidence that the defendant knew that she was going to receive it and how she was going to take it. If there are communications to third parties, any evidence that the defendant, that these were people that the defendant knew or intended that they would pass on the threat to. And to the extent they're publicly posted on social media or elsewhere online, evidence that the defendant intended or knew the victim or a person close to the victim would read it. So one of the things I just wanted to mention before we move on to our questions is that it's important to, I think, for civil attorneys to consult with local prosecutors and for prosecutors to consult with their state attorney general when you have statutes that specify a negligence standard and you're concerned that may not be enough. The concern with consulting with the AG's office, I think it's very problematic for any prosecutor to, on his or her own, put him or herself in the position of essentially conceding that there might be a constitutional issue with the state statute without notice to the AG and their understanding why you're taking that position.
I would just add to that. It's not just a constitutional issue. It's a criminal doctrine question, and you really want a jurisdiction to be on the same page as to what's being argued in the courts in separate cases. Actually, as it happens, D.C. Has now a rehearing scheduled in a case in which the D.C. Court of Appeals a couple of years ago adopted a reasonableness negligence standard for threats, but there had been a kind of conflicting line of cases leading up to that. And as a result of Elonis, the D.C. Court of Appeals has now scheduled a hearing on a rehearing in light of Elonis on the intent question, and DV is hoping and expecting to be able to file an amicus brief in there. But of course, we're going to need to make sure that we are in agreement, will hopefully be in agreement with the prosecutors and also the Office of the Attorney General, which may well come in as well. You really want to have a coherent position and not have different folks on the victim side arguing for different standards. And I want to just reiterate what I think the thing that Terry and I may really disagree about, which is that if you look at our brief and if you look at actually Justice Thomas's dissent in Elonis, we've been prosecuting threats under a reasonableness standard for centuries, and it's never been challenged as a First Amendment problem. And the only thing that seems to have elevated this question to a First Amendment question is the use of social media. I think if this case never would have even gone up to the Supreme Court if it had not been on social media. And I'm not saying it shouldn't have gone up, but we need to be careful before we assume that because it's on social media we have a First Amendment problem, and we need to remember that prosecution of threats has never been seen as a First Amendment issue until now. And so before we leap to the assumption that we have to go beyond negligence as a constitutional matter, let's take a step back and really understand the context historically of how we prosecute and how we've seen the First Amendment in the context of threats prosecutions. And Thomas actually does a really nice job of showing that historically we've been prosecuting threats without any First Amendment concerns, and that we've been using what he calls the general intent standard in relation to speech crimes for all along. So it's clear that the social media context has elevated the First Amendment issue, but it's not clear that it needs to, and we should be thinking carefully about that.
Okay. And if there is no culpability standard specified and there's no default standard, we suggest that you argue for recklessness because that's almost certainly going to be sufficient. And again, prove the highest level of culpability your evidence will support because, as I always like to say, even harmless error is a win. If you're able to present sufficient evidence, then sometimes even if the incorrect standard is charged or they decide that a higher level of mental culpability is required, if you presented sufficient evidence to meet that standard, you might wind up being okay anyway. Additional concerns, just make sure if you're trying a criminal case that your jury instructions are consistent with whatever position you're taking because it's very easy for those jury instructions not to be updated, not to be reviewed carefully, and clearly in Elonis, the jury instructions were actually the entire basis for the error in that case. So very important to look at those.
Yeah,
and anything else you want to say about
I was just going to say that's exactly the situation in D.C. where our jury instructions did not ever match the 2013 decision about reasonableness standard. Instructions stayed at specific intent, and now I think the whole thing will get resolved more finally. In terms of protection order, same thing. I mean, I think it's important for the advocacy community to get together on this, to keep a close eye out. I wouldn't raise the Elonis question unless the other side raises it, but it's, certainly where the other side is represented, and especially if they're represented by a public defender, you can almost expect Elonis to be raised. And so you'll want to know this and be prepared to push back and make the distinctions we've already raised, while also trying to make sure that you have enough evidence to reach a recklessness standard if you need it.
Okay. So at this point, we are prepared to answer any questions that anybody might have. Emily, do you have any questions?
So I'll just connect to the recklessness question here. One question said, I would like to know how the recklessness standard is articulated. If negligence is whether a reasonable person would view as a threat and specific intent is knowledge that a reasonable person would view it as a threat, what is the middle road of recklessness?
Terry, you want to flip back?
Yeah.
Flip back to that slide.
Oh. Well, it just says that you can identify a negligence standard when it says reasonable person. And the question was, how do you identify a recklessness standard, if I understood the question correctly? And so I don't think I need to flip back to the slide.
Yeah, no, that's the slide that has the 4 levels is what I'm talking about. It defines each level.
4 levels.
Yeah, the model penal code.
Yep.
Recklessness, the standard is...
Yeah, usually the statute will simply say recklessly, if that is the standard. Or there will be case law imposing that recklessness standard. There isn't usually other language like reasonable person is for negligence.
Yeah, I think probably the most helpful interpretation of recklessness is conscious disregard. That's what we learned in law school, at least I did, and that's always stayed with me, and that seems to be what the model penal code says. In other words, he was aware she was afraid out there, and he didn't care whether these words were going to add to her fear. And that's different from knowing for sure. It's being aware of the risk versus knowing for sure that she'll be frightened.
Right. And I interpreted the question as being, how would you identify a statute that has the recklessness standard? And usually it just says recklessly, or, with conscious disregard of. That might be another key phrase. In conscious disregard of the risk. That would be reckless. Great.
There were a couple questions related to the state court. So did the case start in state court? If not, why? And a similar question was, any ideas on why they prosecuted under federal and not state law at the time?
You want me to give a stab, Terry?
Yeah, give a stab. You actually worked on the case.
I only worked on it at a pretty high level, so I didn't really get that down in the weeds. But I just presented with Cindy Southworth from the National Network to End Domestic Violence, and she actually had gotten more in the weeds a little bit. And I agree with what she thought, which is that the feds got involved because there was a threat to a kindergarten and federal agent, and neither of us thinks that had it just been threats to the ex-wife and maybe even the coworkers, although that's kind of on the line, we doubt the feds would have gotten involved. And then as for why they used the federal, and then they were able to use the federal statute because it was interstate communication, because it was on social media. At least I'm assuming that. I haven't explored that question. That sounds right to you.
Correct.
Yeah.
That's correct.
So they had the federal predicate because it was interstate communication, because social media, and they chose to use the federal statute because they're federal prosecutors, and that's what they use. That's my read. It was the feds were brought in because it was an FBI agent and a potential kindergarten class, et cetera.
Exactly. I agree with that.
Cindy actually runs the safety net, the technology abuse, or I'm not sure the exact title, but it's about the use of technology to abuse at NNEDV, and she said they have a terrible time getting the federal prosecutors to prosecute these cases at all. And she was kind of astonished that this one was a federal prosecution, but those facts were probably the reason.
Yeah, I would agree with that. Any other questions?
A couple more. Is the prosecution going to retry Elonis?
My understanding is they are. In fact, my understanding is that he is in custody currently because he was on bail pending this, the appeal and the retrial. But I believe the federal prosecutor announced an intention that they would retry him, and he was on the supervised release. However, he, in the interim, was charged with assaulting his girlfriend's mother by throwing a pot at her. And he is now...
Yeah.
Pardon?
I was just trying to remember if it was the ex-girlfriend or the...
No. It was his current girlfriend.
Apparently, right.
Apparently, my understanding is that the new girlfriend allowed him to move in, and when the mom wanted him to leave, he was refusing, and there was an argument, and he allegedly threw a pot at her.
And that violated the terms of his release, so he's in for a probation violation, basically, is my understanding. Or he was in. Do you know if he's still in there? I'm not sure.
My understanding is that he is. There are current posts by him on social media. Of course, it's always possible for someone in custody to have someone else posting. I don't know whether he is in or out, and I just don't know for sure.
Yeah.
And do you all have recommendations if the defense advocates for or the judge tries to apply the Elonis standard to the victim's state of mind?
Well,
ask to file a brief.
Ask to file a brief and reach out to AEquitas. We can certainly assist you with that, because clearly Elonis speaks not at all to the victim's state of mind, and to the extent that the victim has to be a reasonable victim, or fear that would be experienced, be feeling fear that would be experienced by a reasonable victim, it's actually reducing the number of people he could be charged with threatening, because so it's clearly for the defendant's own protection, not something that makes it easier for the state to convict him.
And I will add, since you mentioned help from AEquitas, that DV Leap is now, with the wonderful help of the firm Pillsbury, the national firm, is launching what we're calling a state court monitoring project, which is starting with monitoring for post-Elonis decisions and litigation, because we want to do our best to preserve at least recklessness when the next case goes up to the Supreme Court. So if you have a case that you think is going to put the intent standard squarely in front of the court and result in a case that may well go up at least through your state courts, you might, we would appreciate being notified so we can at least watch it, and then if you think an amicus brief would be helpful, it's something we would consider.
Great. Were there any other questions, Emily? If not, we'll go to our going forward slide.
I think you can move to the going forward. There had been one,
Okay.
and then you all covered it, so thank you.
Yeah, let me just get back up here. Okay. So going forward, as prosecutors or as civil attorneys representing victims, we want to examine our statutes for the culpability standard for threatening or harassing or stalking type communications. Find out what standard is applied, whether it's in the statute or in our case law. Coordinate with other prosecutors or with prosecutors and with the Attorney General's office when you're in doubt about what the appropriate standard should be. If it appears that your statute calls for a negligence standard and you're concerned about that and thinking maybe you should argue recklessness, consult with other folks in your jurisdiction before you do that. And finally, work hard to present evidence showing the defendant's knowledge of the effect of his communication. The higher standard that you're able to prove, the better off you are, the more likely you are to get a guilty verdict, and the more likely you are to be able to keep the victim safe and hold the offender accountable. We've got a few additional resources here. DV Leap's amicus brief, which is wonderful, is available at, and we used a tiny URL because it was quite a lengthy one, but, and again, you will all receive a copy of the materials here. And AEquitas just posted, I think today, it finally went up on our site, our article on Elonis, as well as other resources that are available in the AEquitas library. And please do not hesitate to reach out either to AEquitas or DB Leap or both of us, because Joan and I would love to work together again for any assistance in analyzing or reviewing your state statute.
And I need to add the late-breaking news that we also, DB Leap has also posted an article on Elonis that just is hot off the press today. It's the cover story on the latest issue of the Domestic Violence Report, Volume 20, Number 6, August, September 2015. I am trying to find out, it's posted on our website, so you can definitely find it there. And I'm trying to find out from the publisher how free I am to distribute it. But you can certainly take a look at it that way.
And you can access it at your website.
Yes, and it may also be available at the DV Report website. I haven't been able to confirm that yet.
Okay. Well, that's all we have, Emily.
Well, yes, and thank you to our presenters and to all of you in attendance for your participation and your dedication to increasing victim safety and offender accountability. When you exit ILINC, you'll be sent to equitasresource.org, where you can register for future webinars. And as Terry and Joan were saying, yes, the article will be up and it will be available. We will be sending you the materials, the PowerPoint, and the biographies, and also a link to a SurveyMonkey evaluation of this webinar. And please respond to the follow-up email if you're interested in CLE credits. Please remember, AEquitas is a 24/7 technical assistance provider available to respond to your questions, concerns, and training needs as they relate to prosecution and violence against women. On behalf of AEquitas, thank you for participating in today's webinar.